Hello everyone and welcome to video 3.2.9 for the Legal Studies guy. You will note if you are on the website that this is slightly out of sequence and I'll explain why in a moment. Our quote today from former famous martial artist and movie star Bruce Lee. The successful warrior is the average man with laser-like focus, and all we're trying to get out of this is the idea that you need to make sure you keep that end goal in mind, particularly if you might be watching this during holidays or just early in term 2 when you feel like there's a long way to go. Have that laser-like focus towards the end of the year. Be thinking about the exam, and everything you do now should become hopefully a little bit easier. So 3.2.9. Now, as I said, if you're following along on the website here, you'll note that we've put this up as the 4th video, as opposed to the 9th, as suggested by the study design. So in this dot point, we are looking at the methods used to resolve civil disputes, aka mediation, conciliation, and arbitration. Now, the reason why we're doing this now, or this video is up here, is because if you were in my classroom, we'd be breaking this area of study into 2 SACs. So area 3.2 would be SAC A and SAC B, with SAC A worth 20 and SAC B worth 30. Why we're doing 3.2.9 now is because this is about methods used to resolve civil disputes. Dot point 3.2.4 is about avenues you can go down to solve civil disputes. So Consumer Affairs Victoria and VCAT. So what that enables us to do in my class is to have a SAC on key concepts in civil law, methods to resolve disputes, and avenues to resolve disputes. And then SAC B, which will be dot point 5, 6, 7, 8, 10, 11, 12, 13, will be all about basically going through the court system. So, pre-trial procedures, role of key personnel, remedies, etc. So a little more focused on using the courts and potentially using judicial determination. As opposed to SAC A, which is more about some of the alternatives that you have. So that's why this one appears a little bit out of sync or out of position. Our key skill today is about discussing the appropriateness of methods used to resolve civil disputes. And you'll see that institutions is there, so avenues to go down, which is what we're looking at in the next video. But this one's about how appropriate mediation, conciliation, and arbitration. So we'll look at both what they are and when they're appropriate. So what methods can be used to resolve civil disputes and when are they appropriate, as I said. So what are they, when are they appropriate? So first off the rank is mediation. Mediation is something you may have heard of before. It may even be something that you've been involved in. Often mediation is used in a school setting to resolve disputes between students or even students and teachers. So what mediation is it is a private and confidential process where effectively we all sit around one table, preferably facing each other, unlike this example with Judith, where both parties come to the table and they sit around the one table, and a mediator sits in the middle of them, much like Judith is doing here, and effectively controls the process so that the parties talk through with each other the issues at hand, so that the parties can come to their own resolution. Okay, and this is the important thing. Parties must come to that resolution together and must agree on it. As I said, the mediator's role is to just facilitate that, and with that in mind, there are strict rules of procedure, and they're all about ensuring that both parties are heard and that there is decent discussion. So, for example, a service like the Dispute Settlement Centre of Victoria offers free mediation to individuals in the community, where effectively the role of the mediator is to make sure that both parties are heard, to give both parties a chance to explain their version of events. Following that, the mediator might identify the key issue or the key issues and then allowing the parties to further respond to that and then start coming up with resolutions. So hopefully resolutions that are mutually beneficial. As I just alluded to, both sides get to tell their side of the story. They can use emotions, they can do it in a story sense, they can talk about how they feel, their values, etc. And that allows the mediator to sit there and try and come up with some underlying issues. It isn't like a court case where you must purely respond to questions only. It is about trying to effectively get a solution that suits both parties. This is where it's super important, and this is why I have this capitalized. The mediator's role is to make sure both parties are heard. The mediator does not suggest resolutions. They do not interfere. They do not make the decision. Okay? The mediator is there as an impartial third party, okay, who supports the process but doesn't support the decision. The decision is up to the parties, and this is important because we're going to look at what conciliation is in a minute. This is where the conciliator actually comes up with some potential solutions. As I said, it's private and confidential, and generally it's set up like this, all around one table. Sometimes mediation involving corporations could have both corporations seated in separate rooms, and the mediator would move back and forth between them. You tell me your side of the story, I'll go and see the other party to hear theirs, then I'll come back in and tell you both what I think the issues are, and then we'll start working towards a solution. So that's how corporate mediation might work, but generally you're in the same room and the mediator is trying to get you to agree on something that you come up with yourself. This is where I want to be really, really clear, and I'll allude to this throughout the video as well. Okay, mediation is clearly the least formal of the dispute resolution methods. Okay, it doesn't involve whiz-bang. You don't need to be in a whiz-bang courtroom. You just need to be around a table. There aren't these fancy rules of evidence and procedure. It's about feelings. It's about telling your side of the story. Okay. But what this means is students often have a misconception that mediation can only be used in minor matters. So you should only use this really informal method to resolve minor disputes, and really, really complex and detailed legal matters should be dealt with by the courts. This is completely false, okay? Mediation can be just as appropriate, and we're going to look at appropriateness in a moment, can be just as appropriate for a large-scale dispute, a complex legal issue, as it is for, a matter involving an overhanging tree or payment of a fence between two properties, which are the two most common things that the Dispute Settlement Centre of Victoria has to mediate. So the size of the dispute, the money involved, the complexity doesn't matter. It just has to be, and we'll look at why mediation can be appropriate. It just has to meet some of those guidelines. For example, back in 2011, for a couple of years, the Supreme Court trialled compulsory mediation for all contested civil disputes of a certain type. I can't remember which type off the top of my head. And that mediation was led by a judge, but it was still used the mediation process. And it had somewhere around the 65% success rate, I think was the figure. So that shows that if the Supreme Court's using it with a 65% success rate, that mediation isn't just for really informal minor disputes. So that being said, when is it appropriate? Okay. So again, it doesn't matter about the size of the dispute, but both parties must be willing to attend. There's no point trying to mediate a resolution if one party refuses to turn up. You need both parties there, willing to attend. You need both parties willing to abide by the outcome as well. Okay. No point coming to agreement and then one party not, choosing not to follow it. This is an important note. Mediation in and of itself, an agreement that you come up with someone, is not legally binding. Okay. So that you've got to agree to abide by the outcome. But what will generally happen is parties will sign a terms of settlement, we might call it, which is effectively a contract. So what then happens is if one party fails to follow or abide by the outcome, then you can follow them up for breach of contract effectively. So mediation in and of itself is not binding, but parties will generally sign terms of settlement that makes it binding because they've signed a legal contract. Mediation, and this will be important for when you look at case studies and potentially get asked to justify which method of dispute resolution you would use, is the fact that both parties need to have the future relationship in mind. So one of the key things about mediation is if you're coming up with an agreement together that you both support and you're not being told what to think by a judge or a judicial officer, then there's more chance that you'll be able to continue to interact with each other in the future without any bad blood, without one party feeling like they lost. So this is really important for neighbours, family members, perhaps to employees, to students is why we use it in school, is the idea that if you can both agree on the outcome, when you interact with each other in the future, hopefully there's no bad blood. It's something that you both agree on, you're like, sweet, let's just move on. You've got to be willing to compromise though, because you are not going to get exactly your own way. Both parties have to give a little bit, and obviously want to listen with an open mind to the other's point of view. So effectively, that whole list is the idea that mediation's only going to work if there's cooperation. And that's the buzzword we want you to get to, okay? Mediation is a cooperative dispute resolution method where both parties come together and work through to an agreement that they both support with the support of an impartial third party, the mediator, who does not offer solutions. So that allows us to move into conciliation. And this is where conciliation differs. Effectively, conciliation and mediation are the same. You're resolving disputes in a cooperative manner. There's no rules of evidence. You can talk about feelings and values. The conciliator is an independent third party like the mediator, and it's private and confidential. But importantly, where it is different. Unlike a mediator, a conciliator will actually offer advice to the parties and will suggest potential resolutions. So the conciliator has more of an ability to sit there and think, okay, you said this, how about I throw out the idea that you both agree to do this? So the conciliator can actually come up with the resolution. Both parties still need to agree. Both parties still need to be heard, obviously, but the conciliator throws suggestions out. Misconception number 2 that I want you to, get out of your heads. Okay. Ooh, sorry, I'll flick back into conciliation. What happens is, particularly because we're about to learn about VCAT and then the courts, people easily come up with this misconception that these methods, so mediation, conciliation, and arbitration, which we're about to learn about, are things that are used by, like VCAT, so a different dispute resolution avenue or institution, and that the courts use what we call judicial determination, so a full-blown trial, and that's it, okay? Whereas what we want to make sure we're aware of is the fact that VCAT actually also uses judicial determination. So VCAT can have a full-blown hearing where a VCAT member hands down a verdict that follows the same process that a court trial would. And the courts as well can use mediation, can use conciliation, and can use arbitration. So like I said with mediation, the courts use this in the Supreme Court, for example, with compulsory mediation for all contested disputes of a certain kind. Another example is there was a pilot program a few years ago where certain magistrates' courts sent parties to compulsory mediation for all contested matters under $30,000. So that was in Broadmeadows, Ararat, for example. Again, this mediation was run in the courts. They didn't send it outside the courts to be dealt with by someone else. The courts ran mediation. And this is where conciliation is most commonly used, is in the courts, with what we call case conferences. They yeah, case conferences are a common occurrence in civil disputes that are being dealt with by the courts. And this is where the judge who's in charge of the case will get both parties in. It will be set up like a traditional courtroom, obviously. But the judge will effectively lead discussion amongst the parties about certain points of evidence, perhaps, about how they both see the facts, see if they agree on anything, and then potentially throw out some solutions to the parties that the parties could potentially agree on. What the judge is trying to do here by using conciliation methods and acting as a conciliator is limit the number of issues that need to be discussed at trial, but also potentially get the parties to come to their own agreement before trial, which means you cut out the need for a lengthy trial that's going to cost both parties a lot of money and cost the state a lot of money. So case conferences, really common use of conciliation by the courts. You could also get sent to conciliation in VCAT or use conciliation outside of those bodies, and that's where you make sure your third party offers suggestions. Again, when is conciliation appropriate? And I'm going to start speeding up a bit here to try and meet my 20-minute deadline. It's the same as mediation. You've got to have parties willing to attend, willing to abide by the outcome. There can be a contract signed at the end of it, and there usually is. Future relationship is important, compromise, and listen with an open mind. So again, we are coming back to this whole idea that conciliation is appropriate when parties can cooperate, just like mediation. Finally, we have arbitration. And if I had to put these methods into distinct boxes, conciliation, mediation, very, very similar. Okay, so conciliation and mediation are very, very similar. And then we really ramp up the formality for arbitration and judicial determination, which, as we said, is a court case, which is probably even a little bit further here. But arbitration and judicial determination are really quite similar in terms of the formality. So arbitration is, the key difference with arbitration from conciliation and mediation is that in arbitration, the parties don't actually agree necessarily on the resolution. They might come to their own agreement, but generally the third party, who is the arbitrator, will choose how the dispute will be handled, will choose the process, and will make a legally binding decision. Okay, so the arbitrator actually makes the judgment here, not the parties coming to an agreement. So the parties will put forward evidence. It might be constructed like a normal trial, in the sense of there might be witnesses used, there might be documentary evidence used, but what will happen is the arbitrator will actually ask both parties lots of questions, and be able to ask questions about the evidence, which a judge can't do in a trial. A judge is impartial and can't uncover new evidence. And the idea is that the arbitrator is going to try and find out the truth of the matter and then make a judgment. This judgment might be, a compromise for both parties, or it might be in favour of one party over the other, but it is legally binding. Why do I have a picture of Judge Judy? Because in reality, Judge Judy is a retired judge who, the popular show Judge Judy, is actually an arbitrator, if I could spell that right. So we should almost call her Arbitrator Judy. She is an arbitrator because both parties sign a contract that says they will agree to abide by her decision, whatever she decides. And she gets to question both parties. She gets to question witnesses. There's not a really formal process that's followed, like in the courts, where one party goes first and the other follows. And she ultimately hands down the final decision. So go and check out some YouTube clips of Judge Judy for sure to see arbitration in action. Why is arbitration used over the courts often? Well, mainly because arbitration is private and confidential, and we're going to see in a moment about why big business often gets their disputes resolved through arbitration. because this saves them going to a public court where any dirty laundry they have could be aired, which might be bad for business. Arbitration is appropriate, and perhaps more appropriate in situations like this, where the parties can't come to their own agreement. Okay, you see maybe a mediator or conciliator here annoyed, and therefore a decision needs to be made by a third party that is legally enforceable. And this might be because there's a history of broken promises, so other agreements haven't worked, or just because the parties just are at loggerheads and can't decide. Arbitration is usually reserved or usually used in disputes between businesses. Okay, so arbitration itself is actually really quite difficult to access. It's quite difficult to get someone to arbitrate your dispute through a formal body or an institution. What usually happens is arbitration is usually used by businesses because it's usually part of the contract between two businesses. So when a business writes out a contract, so contract, and the contract might be, we will do this, you will do that, I will do this, you will do that. And then generally there'll be a clause near the end that says, maybe it's clause 37.2. If a dispute arises from this contract, both parties agree to resolve the dispute through, not mediation, through arbitration. So what this means is that if businesses have a contractual dispute, rather than go through the expensive legal process of the courts and filing a writ and getting, they'll get legal representation anyway, but the long waiting times for a trial, they just pull out the contract and say, yep, we've both agreed to arbitration, we'll go and see an arbitrator. For example, I'll link you in the last section to a company called the Melbourne Commercial Arbitration and Mediation Hub, so MCAMH. So this is a company in Melbourne that offers its services out as professional arbitrators. So it says to businesses, if you have a dispute and you've agreed to use arbitration, why don't you come and use us? This is how much we charge, and we will listen to both sides and we will decide on the dispute for you. So it's not accessible for everyone. It's usually only as part of terms of a contract. The skill here is to discuss and justify the appropriateness of institutions and methods used to resolve civil disputes. So obviously get rid of the institutions part. Discuss and justify the appropriateness of methods used to resolve a civil dispute. This is an interesting one. So I think our likely outcomes with this in terms of questions are part B of the exam, which will be case studies, as we know. Likely some civil case studies and potentially some longer response questions around which dispute resolution method would you use and why. Justify that, discuss that, hence the justify here and the discuss. Potentially, though, in the questions we often saw about mediation, arbitration, and conciliation on past exams were more straight along the lines of this. So discuss the effectiveness of mediation as a method to resolve a civil dispute. So just like, how good is it? Like, is it a good method or is it a bad method? This was a direct question off, I think, the 2016 exam, or maybe 15. Straight up, evaluate mediation. Like, is it effective or not? 5 marks. So what's important here is that we do know the strengths and weaknesses of them. So both that we know and included on the slides earlier was when they're appropriate to be used, but then also like why they're good or why they're bad. So often we look at, and generally we can use the same strengths and weaknesses for all of them. And I'm not going to go through these in great detail. I'll allow you to pause and look at them more. But effectively, we talk about mediation, conciliation, and arbitration being effective because generally they're cheaper. So you don't have court fees and legal representation isn't always needed. They're generally quicker, less formal, which can be important to reduce stress and improve accessibility. They're about mutually agreeable outcomes, and they're good for small. I know we said that they're good for all disputes, but they are good for small civil disputes where there's not a lot of money involved, so it would be pointless going to court where it's really expensive. However, weaknesses are, unless there's a contract signed, they're not legally binding. It could still end up in court, so it could add time. They can be too informal, meaning that the truth might not come out because the rules of evidence are too relaxed. Not many people know about them, so they might not know to use them, and they are unsuitable in certain circumstances, particularly if there's a power imbalance, as one party might compromise too much. So, important to know these in case the question is, how good are they, or evaluate their effectiveness. But also if you're asked to justify which method you would use, and you say, I would take this matter to court because the formality of court can remove a power imbalance that exists. Say the scenario is an employer and employee, and we know that mediation and conciliation are not appropriate if there is a power imbalance, as one party will dominate proceedings. So that's justifying which method you would choose based on the strengths and weaknesses. We obviously need to evaluate the ability of the civil justice system to achieve the principles of justice. Pause it now if you want to have a go at this yourself. Accessibility is really important here, and we're going to skip forward in 3, 2, 1. So you can see here that there's a fair bit in terms of principles of justice. Like I said, to finish off, arbitration is generally not accessible for private individuals, only for business. So that's not accessible. However, all 3 methods are really working towards reducing the costs associated with a court case, because you don't have a court case, therefore enabling more people to resolve disputes because they don't have to worry about the cost. Or there could be lack of equality in that one party might have legal representation and the other party might not, because legal representation isn't compulsory, and one party might not be able to afford it, particularly say it's an individual against an organisation or business. But you've got to both agree, like we said, you can only enter into these arbitration if it's in a contract probably, and mediation conciliation only if you cooperate and agree to turn up. So both parties must agree. This is therefore equal. And strong rules of process, particularly in mediation and conciliation, put both parties on equal footing and make sure they're both heard. As well as this, it is fair because mediation and conciliation allow both parties to agree on their own decision that suits them both, but parties might compromise too much, which means the ultimate outcome isn't fair, and lack of rules of evidence might mean that the truth doesn't actually come out. And obviously, fairness is around a just outcome based on the truth of the matter. I've also got here, and I haven't finished it off, that fairness is achieved because an arbitrator may be able to make a decision that suits, that suits both parties. So that's fair, much like in mediation and conciliation, you can agree on a decision that suits you both. To quickly finish off, and I will link these below as always, disputes.vic.gov.au, this is the Dispute Settlement Centre of Victoria's website. It has a tab that tells you all about mediation. It tells you what it is, when it's appropriate, how it works, and why you might want to use mediation, so when it's appropriate. Absolutely recommend you go there. I also absolutely recommend you go here, which is the website for the Melbourne Commercial Arbitration and Mediation Hub. They, much like the Dispute Settlement Centre, have a tab that explains arbitration. This is what it is. This is why you might use it. Particularly important there because they are trying to sell a service. They want you to use them, so they are very much like, this is why arbitration is good. And finally, this section of VCAT, so resolving a case by agreement, is a section all about how you might use mediation, conciliation, or something like that to agree on a resolution without needing to have a hearing. So again, about why you would use those methods and why they're important. So absolutely recommend you read further on these, because these are 3 really complex things that I have hopefully unpacked for you in not quite 20 minutes, a little bit over, but a really dense dot point. So hopefully after we've watched this, you can identify those methods, mediation, conciliation, arbitration, and you can really explain in what situations they are appropriate. This has been the Legal Studies Guy. Thank you for tuning in. Ratings on YouTube, on the website, or on Facebook are all definitely encouraged as we keep burning through Area 3.2.